Yes, Mr. Brown.
My lady, my lords, just two very brief additional factual matters, if I could fit those into the factual matrix that you have before I return to the grounds. The first is page, so Mrs. Nisar's appeal, supplementary bundle, page 176. This is part of the ultimate pre-action protocol letter, or pre-action pro forma. Middle of page 176, as standard in this pro forma, there's a box for the prospective claimant to set out details of the action they want the Home Office to take. And in the 23rd of June 2023 pre-action protocol pro forma, the action sought was a decision to be made and served by the 10th of July 2023. As the court knows, that resulted in the Secretary of State saying that she would provide a decision within 3 months, which led in turn to the 7th of July letter and the Secretary of State's representation or agreement that a decision would be provided more rapidly. So the request was for the 10th of July. The Secretary of State said no. Mrs. Nisar didn't, on the basis of that, decide to seek judicial review. The 7th of July email that then followed at 182 did not, within it, say, if you don't make a decision by the 21st of August, we will start judicial review proceedings the following day. It indicated the prospect of judicial review proceedings afterwards, but it didn't threaten judicial review proceedings forthwith. It wasn't a pre-action pro forma. The response of the 25th of July at 186 set out that a decision would be made by the 21st of August 2023. And I was, in essence, going to return to a question which my Lord the Vice President asked: would the Secretary of State have been better off in relation to somebody saying we're going to take a year to deal with an application for entry clearance? My submission is that it would be unfortunate if the Secretary of State, through agreeing to a shorter period of time, was thereby exposed to a ground of challenge and or costs if the Secretary of State could quite properly have simply insisted on the standard 3-month period. And in fact, the Secretary of State made the decision in relation to this reconsideration in essentially the same period of time as the earlier decisions had been made.
Yes, but isn't the point that there's been repeated trips around the merry-go-round? The implication is that unless you agree to move a bit more quickly, we will go to court. Possibly we will go to court on the substantive issue. So the fact that you're agreeing to produce a decision in a month, so rather than 3 months, it's not something to be just brushed aside on the basis of you could have said 3 months.
Well, my Lord, if the grounds for the delay are exclusively those of the Secretary of State, then I accept that that would be a point of real force. But in my submission, as has been said, there was in essence a reiteration of the same application and a decision in relation to that application without that ever being tested on its merits by a court or tribunal. And the ultimate responsibility for that, in my respectful submission, is the appellant's responsibility, not the respondent's, because the appellant asked on each occasion the respondent to do something, to withdraw the decision and make another decision, and the respondent agreed to do that. But what I may do is take the court first to the relief sought, the grounds, just to seek to, as it were, develop this point. They are in the core bundle at page 118. So the relief sought is an order directing the respondent to make a decision on the application. It doesn't say a favourable decision. And so the terms of the relief sought did not address in Mrs. Nisar's favour the so-called merry-go-round about which complaint had been made. Indeed, the outcome, the decision that was issued in August, perpetuated that very merry-go-round because it was a further refusal. And until this point, at least, the quality of the entry clearance officer's decision-making had never been tested before a court or tribunal. So I accept, of course, that if the outcome of the bringing of the claim had been to force the merry-go-round to stop in the appellant's favour, that could objectively be characterised as success. But that wasn't the outcome of the bringing of the judicial review proceedings. Indeed, it simply perpetuated the merry-go-round. The grounds to which that relief related are set out on the preceding page 117. And the head paragraph 30 complains that the respondent had engaged in ongoing delay in reaching a lawful decision. It's not clear if lawful there is being used as a synonym for a positive decision. But again, if it is, that's not the outcome that was achieved by the appellant, and it appears to mix up the question of delay with the question of the merits of the decisions that had been reached, because the Secretary of State had reached a series of decisions, none of which have been held by a court or tribunal to be unlawful. And it wasn't the Secretary of State who was reopening decision-making time after time, it was the appellant.
The correspondence could have gone first claim, first response, second claim, and third and fourth and fifth, 3-line reply from the Home Office saying you've added nothing, we've got nothing to add either, and we're not going to reconsider, get lost. But that's not what happened. You say that's the claimant's fault. They should have been more aggressive.
Well, I say it's not. I say it's not the respondent's fault. It's not conduct on behalf of the respondent, which was public law unlawful, or importantly, ultimately resulted in the appellant's success in the proceedings that were brought. And in particular, if it is a premise of the judicial review that the decision should have been a favourable decision, then there very clearly wasn't success against that benchmark. And I submit that the upper tribunal judge can't be criticised for taking the grounds of judicial review at face value. The only reference to an express agreement to conclude the matter by the 21st of August on page 117 is paragraph 30.4. And so far in my submission from this being a claim which was founded on that agreement, it is one of many matters which are relied on by the claimants in the context of a claim which appears to mix questions of delay with questions of the quality of decision-making and the legality of decision-making, even though that wasn't a matter for the Upper Tribunal in the judicial review, and even though the decision that was reached on the same day was one adverse to the appellants. So those are the additional factual matters that I'd wanted to address in relation to the Nisar appeal. In relation to Mr. Mammedov, again in my submission there is a blurring in the challenges made between questions of delay and questions of merits. These can be seen in the pre-action correspondence. I could take the court in the supplementary bundle in Mr. Mammedov's appeal to page 70.
$17.
70, my lord.
17.
The very top of page 70 is part of the box which starts on page 68, headed "The issue," set out a brief summary of the facts and relevant legal principles, dates and details of the act or omission and why it's contended to be wrong. But at the top of page 70, paragraph 11 is in fact clearly details of the action which Mr. Mammedov wants the Home Office to take. The respondent is therefore required to withdraw the decision and grant the applicant visit visa. So within the body of one box, in which in fact the substance of the claim has been set out, the requested action or relief is withdraw the decision and grant a positive decision. But immediately below that, in the box for setting out the details of the action that you want the Home Office to take, the only request is for a withdrawal of the decision. There isn't a request for the visit visa to be granted. Once again, it was entirely open in my submission when the response to the pre-action protocol letter was received, which didn't grant a visit visa, for Mr. Mammedov to bring proceedings on the basis that there'd been a refusal of the action requested, but that didn't happen. And the same tension between the relief sought in 2 points of the form can be seen in the next pre-action letter at page 88 in the same bundle. Once again, in the substantial box at the top of the page, the last paragraph requires the respondent to withdraw the decision and grant the applicant visit visa. But that same form of relief is not sought in the box that immediately follows and is particular to the relief sought. Once again in my submission, there is then a blurring of grounds relating to delay with grounds relating to a grant of entry clearance as a visitor. And the relief sought in relation to Mr. Mammedov is different to that sought in relation to Mrs. Nisar, who only ever sought withdrawals of the decisions. If, therefore, Mr. in the detailed text of the pre-action protocol letter. Once again, he falls short of it. He didn't get a grant of entry clearance as a visitor. He only got an adverse decision. I then just wanted very, very briefly to go over the chronology which immediately precedes the starting of the claim in Mr. Mammedov's case, though I realise that this was touched on by my learned friend when he opened the appeal. So having said on the 20th of December that barring complexities, the Secretary of State aimed to issue a reconsidered decision by the 20th of March, on Friday the 21st of February, the entry clearance officer seeks evidence that Mr. Mammedov has had permission to work in Turkey at the time of the application, and that's in the supplementary bundle at page 101. There is no evidence of any response to that. The request is then made again on the 17th of March, pages 105 to 106. And Mr. Mammedov responds that evening at 104. This, in my submission, is an area where there is a risk that the entry clearance officer is damned if they do and damned if they don't. It's a request for more information about a matter which the entry clearance officer considers is relevant. The request is made in February. There is no answer at all. A further request is made, and Mr. Mammedov responds to it in the way that he does. I've set out in my skeleton why in my submission it was a relevant matter for the entry clearance officer to address, because in Mr. Mammedov's application for entry clearance, he had said that he had had small job opportunities for which he'd been paid. He was not a Turkish national. He was apparently in Turkey on a student visa. And it was not self-evident that as a student in Turkey, he had a right to work. And it would be directly relevant to a consideration whether somebody should be granted entry clearance as a visitor to the United Kingdom, whether they have been acting in accordance with the conditions of their entry and stay in another country. So if the entry clearance officer hadn't asked about it and then had reached a decision, there's every chance that that would have been a ground for criticism. And so in my submission, it was entirely proper for the entry clearance officer to ask about it, and indeed to ask about it twice. The timing of it is relevant because plainly Mr. Mammedov knew about it and knew that inquiries were being made on the 17th of March, just a few days before the 20th of March watershed. If I can then turn to the grounds in Mr. Mammedov's claim for judicial review, those are in the core bundle. We start at page 112. There are two grounds: procedural impropriety and Wednesbury unreasonableness. Under the heading procedural impropriety, complaint is made of the overall time that it has taken to address Mr. Mammedov's entry clearance application. At the top of page 113, it is said that on each occasion has warranted an additional 3-month time period for reconsideration. For the reasons I set out earlier, that it isn't factually accurate, at least insofar as the time that had been taken was concerned, because the first application had been decided within 3 weeks and the second application had been decided within 4 weeks. So the Secretary of State had indicated that it might take up to 3 months, but had then in fact decided the application on each occasion within a matter of weeks, a very much shorter time. But that fact isn't evident anywhere on the face of the grounds of complaint. On page 113 at 8C, it is alleged that the respondent has had the same facts and there have been no changes, but there have been a number of changes, which included the fact that the main reason for the visit, that is the appellant's girlfriend's birthday, had passed. By the time of this claim, the appellant was engaged in an internship in Turkey, and also that the evidence of his ability to reside in Turkey had expired sometime previously. At 8D, it was contended that the pre-action response of the 20th of December confirmed that a decision would be forthcoming in 3 months, but in my submission that doesn't quite set out what had been said in the pre-action response. That was that absent complexity, barring complexity, the Secretary of State aimed to make a decision within 3 months. And at paragraph 8E, by the time of the claim, the appellant knew that the Secretary of State had raised an issue about the appellant's right to work in Turkey, which the appellant had firstly ignored and then declined to engage with.
Yes, you made that point
Yes.
a few minutes ago.
Then under the heading Wednesbury unreasonableness over the page, at paragraph 11, the appellant's ground said it's important to highlight here that the applicant is not alleging that the delay is unlawful, but failure to make a decision within the time limit provided by the respondent, coupled with no communication and no evidence, information of any special circumstances. So on the one hand, there appeared to be a complaint that it was the delay that was unlawful, but here it appeared to be said that there wasn't a challenge on the basis of delay. Can I turn then to the two decisions of the respective Upper Tribunal judges? In Mrs. Nisar's case, the decision of Upper Tribunal Judge Sheridan is in the core bundle starting at page 17. The first criticism made by my learned friend of the decision is that there wasn't an identification of which of the M and Croydon categories the decision fell into. I submit that was because it was well understood by everybody that there was no factual causation between the issuing or making of the decision and the bringing of the judicial review proceedings. The decision had been drafted and the judicial review proceedings had been started on the same day, and everybody understood that. So as a matter of causation, the starting of the judicial review proceedings had not led to the refusal of entry clearance.
That seems to be the main basis of the same judge's decision refusing permission to appeal. But is it rational?
Well, that isn't the end of the judge's decision making no order as to costs. it's, if you like, the starting point.
No, but is that holding no causative effect because unknown to the claimant the decision had already been made? Does that make sense?
In my submission, it does, because as a matter of logic, since the Secretary of State did not know that judicial review proceedings had been started, those judicial review proceedings could not have caused the 22nd of August decision to be made, or to be made more quickly than it otherwise would have been made.
Is there a difference between the threat of judicial proceedings and the actual issue of judicial proceedings in causation terms?
In my submission, yes.
Is there any authority for that? I thought that's the main point we had to decide, and it's never been decided before. Am I right in thinking it's never been decided before?
I'm not aware of any authority that deals with threats, because threats to issue proceedings will be relatively common given the protocol on pre-action conduct. And in any event, my lord, what I submit in light of the authorities that the court has been taken through is that while in many cases the correlation between starting proceedings and achieving an outcome will be indicative of success in whole or in part, the authorities say that isn't the end of the factual inquiry, because the court needs to do its best, having regard to proportionality, to inquire into the underlying legal merits of the claim, since otherwise there could be a range of circumstances in which, just as here, there is essentially a coincidence between the issuing of proceedings and the reaching of a particular decision, which might be to a greater or lesser extent favourable or unfavourable to the person who's just started the proceedings. So that in my submission is why the Upper Tribunal judge didn't apply M, because the judge proceeded on the basis that the paradigms which M sets out simply didn't apply, where there had been a coincidence of action rather than some causal relationship between action on the two sides of a piece of litigation. Having reached that conclusion, in my submission, the Upper Tribunal judge was entitled to take into account that there were things that each side could have done on or around the 21st of August to avoid the litigation being started. The judge certainly didn't hold everything against the appellant, nor did the judge hold everything against the respondent. And in my submission, it was a rational decision for the judge to conclude factually that each side could have done something, neither side had done anything, and in those circumstances the just order was no order as to costs. Mr. Malik suggests that there is inconsistency, that this was ultimately an area for discretionary decision making by the judge, doing the best that they could on the particular factual circumstances of this case, and in my submission it betrays no legal error. In particular, however, given the grounds of the appellant's claim for judicial review, it was also not an error for the Upper Tribunal judge to conclude that the Secretary of State's position on reaching a decision by the 21st of August wasn't an undertaking. And the Upper Tribunal judge was critical of the Secretary of State. On page 70, paragraph 4, the judge criticises the Secretary of State's conduct in circumstances where each side was seeking their costs. And that was plainly relevant to the judge's decision not to award the Secretary of State her costs. Turning to the Upper Tribunal judge's decision in Mammedov, this is at page 55 in the core bundle in Mr. Mammedov's view. I submit that the factual circumstances relating to Mr. Mammedov are in many ways weaker than those of Mrs. Nisar, the one exception being that the same coincidence in decision-making isn't the case for Mr. Mammedov. The Secretary of State's decision had been reached some time after the issuing and service of the proceedings. But there had been overall a much shorter period of delay in Mr. Mammedov's case. The first decisions had been reached much more quickly. There had been engagement between the entry clearance officer and Mr. Mammedov in the days prior to the start of this claim. And the key, of course, Upper Tribunal Judge Hurst did consider whether Mr. Mammedov was the successful party or not, and concluded that he was the successful party. Paragraph 6 of the judge's decision at page 56. But the judge considered that Mr. Mammedov hadn't started pre-action correspondence in relation to the delay issue. Again, in my submission, that was a legitimate decision for the judge to reach, which betrays no error of law. The judge considered the operative pre-action protocol letter, which was the 13th of December 2024 letter. That did not complain that proceedings would be issued if a further decision was not taken by the 20th of March. And in my submission, it was plainly right for the judge to reject a submission that the 16th of March email was pre-action correspondence, given the timing between that and the start of the judicial review proceedings, and given that the 16th of March 2025 email gave the respondent no opportunity even to respond to it if it was a pre-action letter. It was simply expressed to be a reminder to make and serve a decision by the 20th of March. All proceedings would be started without further notice. So far as those two factual assessments are concerned, in my submission, neither betrays any error of law by the judge. And in my submission, the judge was lawfully entitled to take those two matters into account, again in deciding to make no order as to costs on the basis that there hadn't been proper pre-action conduct by Mr. Mammedov before starting the March 2025 claim. My lady, my lords, unless I can help you any further, those are my submissions.
Thank you. 5 minutes ahead of time. Thank you. Yes, Mr. Malik.
My Lord, the Vice President asked a question when my learned friend was making his submissions whether he accepted that these were category 1 cases. Mammedov in response submitted that case law that followed M versus Croydon had qualified M versus Croydon to some extent. In my respectful submission, that isn't the proper analysis of the subsequent case law. So in my opening submissions, I took the court to paragraph 59 of M versus Croydon, where Lord Neuberger had said that where a claimant obtains the relief sought in the judicial review claim, he is undoubtedly the successful party and entitled to his costs, unless there are good reasons to depart from that approach. In my respectful submission, the subsequent case law does not seek to interfere with the way in which Lord Neuberger had categorized the cases, but gave guidance as to what good reasons entail in that context. So where an applicant has obtained the relief sought, but where the claim is hopeless, or where the relief that is granted was because of an entirely external reason, or where it was unreasonable for the claimant to bring the judicial review claim, despite the fact that that is a category 1 case, no order as to costs would be appropriate. Mammedov, Lady and Lords, you'll recall, took you to 3 judgments. And may I just make very brief submissions as to those 3 judgments and show you why, on analysis, they do not assist Mammedov. So the first judgment that he took you to was the judgment of the Upper Tribunal, which is behind tab 14 of the bundle. This is the judgment of Ms. Justice Smith and Upper Tribunal Judge Smith. The paragraphs that Mammedov invited you to read in my submission must be read in the context that is set out in detail under the heading the judicial review claim at page 216. So this case concerned the Rwanda policy. There was a challenge by the claimant, and the policy then changed. If you look at page 220, right at the end of that page, you'll see a heading, the afternoon before the hearing. The afternoon before the hearing, the Home Secretary published a statement, and that statement essentially had said that the relevant claims would be dealt with on merits. The issue in that
where's the reference to the statement?
Yes, if you paragraph 16 of the judgment, page 220.
Oh, sorry.
Shortly before the hearing, the Home Secretary said that she would discontinue, the Home Office has discontinued inadmissibility actions. So this is where the Home Secretary was saying that she's not going to consider the asylum claims. Mammedov took you to paragraphs 21 and 24 and 26 is where Upper Tribunal refers to Z in Afghanistan, the authority that I showed you. The reasons, the key reasons for the Upper Tribunal for making the decision that it made are set out at paragraph 27 and in the following paragraph. So paragraph 27, the Upper Tribunal concludes that inappropriate that this isn't a case where the Secretary of State should pay the applicant's costs. And then if you look at paragraph 28, that is the first reason. First, the appellant's case, whether originally pleaded or in its proposed amended form, was a very weak claim. So this is the point that Dr. Singh was making in ZN. And indeed, if you look at the analysis, paragraph 32, one of the grounds was hopeless. So if you have a very weak case, if you have a claim that is hopeless, you don't get your costs. But this is not that case. Miller and Trent does not submit that the claim for judicial review advanced by these two appellants was a hopeless claim or was a very weak claim. The second reason the Upper Tribunal gave is one that is set out at paragraph 34. That paragraph starts with second, and the point is that there was no sufficient reason for the claimant in that case to commence judicial review proceedings. Not this case.
I think Mr. Brown cited this case mainly, as I understood it, for the sentence about 5 lines up from the bottom of paragraph 26, which links this chimes with your submission that these cases are identifying circumstances in which are in or not in, or Neuberger's category 1, and the proposition there is that causation is one of those things that you have to consider, and if there's no causal link between the merits of the underlying claim, not just the fact of the claim, but the merits of the claim, and what happens, then you're outside category 1. That's the case.
Yes.
And you have confronted that in your own case.
I have. And it's entirely, of course, a matter for the court as to whether the court concludes that causation is relevant to categorization, or whether it's relevant to a good reason as to why it is appropriate to depart from
Well, that may be
the proper approach.
an analytical question that doesn't need to matter very much.
Yeah. Yes. So I'll leave it in. My submission is that M versus Croydon is binding, and all ZN Afghanistan is doing is explaining what a good reason could be to depart from the general principle, rather than seeking to interfere with the categorization. But you have my submission on causation. The next authority that Milan took you was the judgment of this court in AL. And Milan took you to this judgment in response to a question by the Vice President as to the circumstances in which the Judicial Review Court would interfere in delay in the decision-making process. In my respectful submission, paragraph 2 of that judgment will reveal immediately as to why that case is so very different from this case. So tab 11. Tab 11.
Paragraph 2.
Paragraph 2.
Thank you.
Page 174.
Thank you.
Paragraph 2, that was a case where the Secretary of State gave a time frame, promised a time frame, and made a decision within that time frame. This case is completely opposite of that case. Yes, and if you wish to see more, then see paragraphs 4 and 5 of the judgment, where the Secretary of State's position is set out that he would make a decision within 6 months, claim is issued, and the Secretary of State made a decision within the promised time frame. So I'm not sure with respect how this judgment can assist Miller and Friend. The court made a point, obviously, that Secretary of State has made a decision within the promised time frame, and there's nothing irrational about it, but not this case for sure. The final authority that Miller and Friend took you to is the judgment of this court in Ulla. You have that behind tab 13 of the bundle. And again, with respect, when you will look at the background of the case, you'll immediately see that that case is completely different from this case. So if you go to page 202 of the bundle, there is a heading grounds of judicial review. That isn't a case about the promise. Ground is that the Secretary of State acted unreasonably and contrary to common law duty of fairness.
So where were you reading from?
Lord, this is
Paragraph 25, is this?
paragraph 25, yes, grounds of judicial review. So that is the context.
It goes on to deal with the question of delay and efficiency.
Yes, about in terms of standard timeframes. So the Secretary of State has sort of published standard timeframes that she would decide X application in X months, etc. But that isn't the case where the Secretary of State sent a correspondence saying that she will make a decision by a particular date. There's no dispute as to what is said at paragraph 62. But just one particular sentence, you have been taken to paragraph 62, but may I ask you to look at the last sentence of that particular paragraph. This is page 211. Lady Justice Elizabeth Lenk says that the Secretary of State was entitled to defer making a decision until she had investigated the matter, investigated the sponsor to the extent that she considered appropriate. So no dispute. If the Secretary of State needed more time to investigate these applications, then all she has to do is to evidence it and put forward that as a special circumstance or a good reason why she wasn't able to comply with that promise. The problem for the Secretary of State is that isn't a justification that is put forward. It isn't suggested that the Secretary of State needed more time to investigate these applications. None of these authorities support the proposition that Miller and Friend sought to put forward in response to a question by my Lord the Vice President, that the fact that these are entry clearance cases is somehow relevant. There is no special rule for entry clearance cases, and it would be, in my submission, quite wrong to create one. Conduct is relevant, and the fact that this was the 5th round is relevant. Just finally, Miller and Friend took you to the pleadings in both cases. And in the case of Nisar, the purpose of Miller and Friend showing you the pleadings was, I think, to make the point that the claim was advanced on the basis that this was a typical FH delay case, where the Secretary of State was unreasonably delaying making a decision. That plainly is not the case. May I just show you just a couple of passages in the pleadings just to respond to what Miller and Friend said. So if you look at the core bundle in Nisar, And if you look at page 113, so my learned friend showed you this page, the heading grounds of judicial review. The learned friend says that, well, this is the primary point that is made. The first authority that is cited is FH. But before you look at this, you do, of course, look at what is set out at paragraphs 20 and 21.
Yes.
And then my learned friend says that if you look at the next page, the second authority that is cited is also not about promise. And then the third authority is also about a sort of conventional case about delay. And that's how the appellant was putting the case. Well, this, with respect, simply ignores what paragraph 28 says. The reason why the appellant cited those cases was to demonstrate that they are distinguishable. The following principles distinguish the case from being an FH-style delay complaint. So the appellant wasn't citing these cases to rely on them, but to demonstrate that these are different cases. And then those reasons are set out. And see paragraphs 30.3, 30.4, and 30.5 fail to follow the undertaking or the promise, fail to follow through the agreement, no special circumstances, repeated refusals with similar identical reasons. There's no doubt that this case was properly pleaded, and the relevant points were clearly identified. So there isn't, in my submission, a proper basis to suggest that this was pleaded as an FH-style delay case. Mammedov then took you to the pleadings in Mammedov for the same reason. May I just show you the pleadings in Mammedov just to respond to the point that Mammedov made. The pleadings in Mammedov are in the core bundle. Page 109. And if there is any doubt as to what the claim is, the doubt in my submission will disappear when you look at the very first paragraph of the grounds. The applicant seeks to challenge the respondent's ongoing failure to make a decision within the time frame that the respondent itself set proposed. Factual narrative is then set out in full, and there is a ground about procedure at page 112, and that ground is all about failure to make a decision within the promised time frame. See, for example, paragraph 7. So the claims were properly pleaded for the reasons I've given. The claims caused or contributed to the service of the Secretary of State's decisions. Service is what is relevant. This isn't a case where the underlying claims are without merit. They are very strong cases. It is not suggested, it cannot be suggested that it was unreasonable for the applicants to bring these judicial review proceedings. I'm very, very grateful for your patience. Unless I can assist you any further, these are my submissions.
Thank you. Thank you very much, Mr. Malik. Thank you all very much for your assistance. We'll reserve judgment. Council know what I'm going to say next, but I have to say it anyway. In every case, we will send out a draft decision, almost certainly a judgment headed in both cases. Same legal teams, so that won't cause any difficulty. We send it out in draft, not for the case to be re-argued, but for the correction of any obvious factual errors like wrong dates and typos and so on. We ask counsel to agree the form of order, any consequential matters. We then hand down the decision digitally, in the sense of publishing it on the National Archive website and elsewhere, and until it's published, the contents of the draft judgment are confidential to the appellants and their legal advisors on that side, and the Secretary of State's legal advisors and anyone who has to know within the Home Office on the other side. Thank you all very much.